child custody and filing where you live and court's jurisdiction. So today I was, we had clients hire us. They sent me their paperwork they had filed in 2020. I was looking at their paperwork and they had even tried to submit their judgment, and they had the judgment reject sheet from the court. I'm trying to remember what court this was, maybe Santa Clara or one of my favorite courts not to deal with. But they had on the UCCJA, this is the FL 105, you have to put where the children have lived the last 5 years. And I noticed they wrote New York on there, and it was 3 years old. So I thought, well, maybe they were in California at the time. And then I couldn't understand why they filed a California divorce case if she's living in New York and that's where the child resides. And I also saw that they had the judgment rejected. And one of the clerk's notes was, it appears according to your FL 105 that in the last 6 months or even 5 years, I think the child was 3, that the child hasn't lived in California. And we're not certain that we have jurisdiction over the child to be able to make child custody orders, meaning orders in that they are confirming what the parties agreed to. So we would have put it together in a normal case, their agreement regarding child custody. It becomes an order when the judge signs it. But what the court's saying is, I don't think we can sign the child custody agreement because we don't have jurisdiction to do so. So I asked the client, hey, said, did the child ever live in California or around the time you guys filed? No, the child has never lived in California, always in New York. That's going to be a huge problem. I'm guessing the reason they filed this in California was because the petitioner lived in California. I would suggest you always file in the state where the child has lived for the last 6 months. By the way, that's going to be required anyways, because if you move, like if this person lived in California, then moved to New York, and she was a respondent, moved to New York and was there 6 months, California no longer has even jurisdiction to be able to accept the case in California, because you have to reside in the county for 3 and state for 6. So she would have had to file in New York. I think I'm going to have to recommend to them that she either dismiss this case and they file in New York so they can get custody orders, or, and this only happened one other time in 11 years where the same issue occurred. It was an LA County case. We filed the judgment without the custody orders, and the court rejected it because they didn't have jurisdiction. And it's happened 2 other times, because the first time it got approved in one downtown court, and then in Chatsworth court, they rejected it, saying there's no child custody orders. And I said, hey, you guys don't have jurisdiction. They rejected it again. And then I attached a copy of the approval we got on another case from downtown, and then miraculously they approved it. I always file in downtown for that reason. I think they have the best and the brightest and most knowledgeable clerks in all of LA County. So wherever you live in LA County, that's where I'm going to file your case. And that is the end of Divorce 661's Daily Perspective, episode 3. We'll talk to you tomorrow.